Welcome to the Generis Show, your unique perspective on everything you need to know about your civil rights and the criminal injustice system. With Erica Merrill, I'm attorney Brian Jones, criminal defense and civil rights warrior. Today in segment one, we'll be discussing the murder of an unarmed white teenager by an Arkansas sheriff's deputy, the rape prosecution of a man in Florida who voluntarily submitted his DNA to online databases, and the release of Bill Cosby after his conviction was vacated by the Pennsylvania Supreme Court. In segment two, as promised, we'll be discussing why there are exceptions to the Fourth Amendment's warrant requirement. To make sure you don't miss an episode, subscribe on Apple Podcasts, Spotify, and YouTube. Look to the law office of brianjones.com and all of our social media outlets for everything you need to know about the latest developments in your civil rights and the criminal injustice system. Erica, did you see in the news this week, 17-year-old Hunter Brittain becomes the latest victim of police brutality, sparking outrage and protest in Arkansas?
Yeah, this is a really sad situation. And I mean, it just seems like you can't do anything anymore without getting shot when the cops pull you over. So, how did this young man come to the attention of law enforcement?
Hunter was out test driving a truck that he had been repairing at about 3 a.m. He'd been up all night to make sure that he could go to work in the morning. And the truck started to malfunction, so he pulled over to try and make some repairs on the road to get back to his house slash repair garage. And a deputy pulled in behind Hunter and his friend and turned on his overhead lights. When Hunter stepped out of the vehicle and attempted to place a bottle of antifreeze behind the wheel to chalk it so that the vehicle didn't roll backwards, the deputy shot him. The friend that was in the truck with him said that there was no warning, nothing was said before shots were fired, multiple shots striking Hunter in the neck and ultimately killing him.
It's horrible. So, I mean, I've heard that there's a lot of outrage in the community. There's a lot of protesting, and rightly so. Can you tell us a little bit about the significance of the protesting against this event?
Well, Hunter Brittain was a bit of a local celebrity. He was well known for his aspirations to one day become a NASCAR driver and was deeply rooted in his community. There have been a variety of social media posts, several of which have gone viral over the weekend, and the incident has now garnered national attention from activists and the media. The community has held vigils. They have burned boxes of donuts in the sheriff's parking lot, which I think is by far the greatest protest we have seen to any of these officer-involved shootings. And the continued protests continue through this weekend to the senseless murder of a child by a police officer. What's really interesting about this case, Erica, is that this is a white community and Hunter is a white man. It's important to remember that the victims of police brutality come from every race, ethnicity, religion, and that anybody can be gunned down by a police officer in any interaction with those police officers. Until police change their mentality that they are warriors in a combat zone and we citizens are the enemy, this will continue to happen day in and day out in America. And they will continue to engage in inhumane and brutal treatment of the people until they are put in check. This is why police reform is so critical.
I can see that. It's just surprising that with all the press and all of the events that have happened over the past few years, it feels like it's happening more and more, getting a lot more press, a lot more protesting, that this continues to happen, especially in an all-white community now. And like you said, it can happen to anyone. So how does this support of the NAACP influence the effort to get justice for Hunter Brittain?
Police reform activists, social justice activists, and the leaders of the NAACP, as well as a variety of other national Black organizations, have thrown their support behind this community. The support of these organizations is critical because, and this is the irony, is that these are the organizations that have the experience in organizing protests, in advertising events, in transporting participants and supporting anybody who is in need, both from the trauma that this community is experiencing as the result of this officer murdering this young man, as well as the trauma that they will experience from the inevitable backlash from police who don't like to have their wrong, illegal behavior brought to the public's attention. So there will be no doubt a variety of arrests of innocent, peaceful protesters over the coming days and weeks. These are the organizations that have the infrastructure, that have the backing, that have the knowledge on how to deal with these traumas that this community is experiencing. The fight to reform policing is not a minority fight. It is a fight that every single American has to be concerned with. And going into our Independence Day weekend, this is a time among all times to recognize that this government is starting to behave very similarly to that of King George's government when we overthrew them. There needs to be reform before there is violent backlash, because the citizen will only take this for so long. We saw the uprising last summer. I would anticipate that if this continues, those uprisings are only going to get worse. Police need to acknowledge the wrongfulness of their behavior and agree to reforming their behavior, or else this could get out of hand very quickly.
No, I'm really afraid for our nation, uh, because they do seem to be getting more and more violent. And not saying that there's no reason for it, because as we pointed out in the past, it's terrible to watch sometimes, but we are finding reform happening in certain states, and some of the laws are changing for the better.
Well, most importantly, it's working, Erica. We see time and time again, as we discussed several episodes ago, that Colorado is having a drastic reduction in, well, officer involved shootings have been eliminated. Um, but officer involved violence has dropped drastically. Complaints against officers have dropped drastically. Respect for law enforcement has gone up significantly. And that's just one example of a community. You have similar progress in Minneapolis. You have similar progress in Portland. What we see is when reform goes through, that the community is safer and they respect police more. And if you as a law enforcement officer are against reforming the police, you are against being nonviolent with the citizens, and you are against the citizens respecting police. There's no debate about those facts.
I'm so happy that reform is happening, and I just wish we didn't have to go through all this violence to get there, and have more of these shootings. And it's very disturbing, and I just hope that the police do accept that they need reform.
Absolutely. And speaking of people who need reform, Erica, Florida, just Florida. Florida needs drastic amounts of reform. But more particularly, did you see in the news this week that Florida man was indicted on a 14-year-old rape charge after entering his own DNA into a genealogy database and agreeing to have that DNA turned over to law enforcement?
Brian, I just yes, Florida. That's all you have to say sometimes. Um, no, I have a lot of friends that live in Florida, so I don't want to really insult them. A lot of attorneys, in fact, but I mean, these stories do tend to come out of Florida. Um, um, Ken, I, I mean, I know we did an episode on this. I feel like it was just last year, maybe about a year ago, where we talked about how if you submit your DNA to these genealogy companies, that and it's anyone's game then. And maybe you could tell us a little bit more about how he voluntarily submitted a sample, and how it got into the hands of law enforcement.
Yeah, so Jared Vaughn should have been listening to the Sui Generis show last year. And if he had, he would not have entered his DNA into not one, but two genealogical databases, GED Match and Family Tree, and opted in for law enforcement sharing. Now, the police collected a DNA sample during an investigation of an on campus rape 14 years ago. And that sample was entered into the CODIS database. CODIS is the combined DNA indexing system that's maintained by the Federal Bureau of Investigation. It's basically a database of all the crime-related DNA samples collected for dozens of years. Old samples are being entered in every single day. And law enforcement conducts routine screens of this database, comparing, cold case unknown samples to new known samples. And lo and behold, they have a hit, and it's Jared Vaughn. And next thing Jared knows, he's on his way to the Huskow.
Wow. I bet you he was surprised. that that's a long time to have gotten away with something, and then all of a sudden you think that you're doing something innocently, like checking out your genealogy. I mean, I wonder what the results of that test were, besides not being so smart. Is law enforcement use a risk with every DNA database service?
Yes, always. Yes. All of these services have detailed terms of services which outline when and how they will disclose your information to the police or third parties like child support enforcement agencies, even private third parties. As the user, you have to be aware of the settings and the opt in and opt out choices that you make while signing up to use these services. But I think more importantly, Erica, just to reiterate our conversation from, again, about a year ago, anytime you release your DNA to a provider for an assessment that isn't medical, you are releasing control over that genetic code, and you cannot be certain whether it will be used for genetic research, whether it will be turned over to law enforcement, whether it could be subpoenaed, whether it could be stolen, both by the government, by third parties, or foreign nations. You have no control over your genetic code. It is probably the most private aspect of your body. And I'm shocked that millions of people do this every single day.
Okay, so as an attorney, that you're a criminal defense attorney, and I'm sure you've seen this before. Um, is there any legal protection against the use of a sample submitted for one purpose, like genealogy, but then used for another, like prosecution in jail?
Well, so there are challenges that can be made, but they go more to the weight that a jury would ultimately give the evidence rather than the evidence's admissibility in court at all. The evidentiary challenges can be raised in both the civil and criminal context, but ultimately, if you voluntarily produce the sample and provided all the necessary permissions, it's going to be really hard to keep that DNA result out of court. Now, was it collected properly? Was it sterilized? Was the collections, was the collection stick sterilized? Was the sample collected in an appropriate manner? Was it stored properly? Was it transported properly? Was it opened, tested, analyzed, amplified, all properly? All of those challenges remain. And really, with these private corporations and an individual collecting their own sample, becomes much more difficult to link up those chain of custody links and make sure that this evidence is the quality evidence that we want in a criminal court in particular. Even in a civil court, we want to have quality evidence. It also kind of depends on the type of the DNA match. Are we talking about Y chromosome short tandem repeats? Are we talking about regular short tandem repeats? Are we talking about mRNA testing? Law enforcement can use any of these samples any of these testing types rather, to match as a preliminary test and then secure a warrant to get a more sophisticated test. There will be an uphill battle in fighting these private services for their records, identifying their testing rate errors and other contextual data that's important for determining the reliability of a particular match. But if it's only being used for identification and to kick off an investigation, all of that may become irrelevant.
I mean, yeah, I mean, it's interesting you say that because I know in the past we've spoken about how even when there's a DUI, for example, all of those test results are constantly looked at for, what are they doing with the sample? How long is the sample sitting out before they put it in the refrigerator? How are they collecting it? What's the time between the arrest and the collection? There's a lot of different factors, and I mean I can't even imagine what it's like now with just your average Joe putting a swab in his mouth and sending it off in the mail. I mean, I'm sure it's not a refrigerated package. It just sounds pretty crazy.
Absolutely. And the collection being the first step in this scientific experiment, um, really sets the dominoes in motion to lead to inaccurate results down the road. So I think these private testing procedures or these private testing labs and the results that they produce, they've got some challenges. But again, it goes to what weight is the jury going to give as opposed to their admissibility. The jury's going to hear about it. It's just how convincing is that information. Uh, so we'll wait and see. Certainly, this is an area that we are going to continue to watch. Um, and a story that I think will also garner additional watching because it's not over yet is the story of Bill Cosby. And just yesterday, his conviction was overturned for counts of rape in Pennsylvania, and he has been freed from prison.
I just saw this on one of the news shows last night, and it, what that person said was it was a technicality, and it sounds crazy. So, can you tell us, why was this conviction overturned? I mean, this was a very long trial with a lot of women coming forward. It seems like this would be an impossible event for him to get out of jail after all that occurred over the past few years to put him there.
So the case was ultimately overturned because Cosby was given assurances that his statements, his deposition in the civil lawsuit about a decade or more ago, would never be used against him and he would never be criminally prosecuted for his statements given in that civil deposition. He was essentially given immunity for anything that he would say during the course of that civil deposition. And ultimately those statements were used against him in the criminal trial, and the prosecution therefore violated that contract and violated Bill Cosby's Fifth Amendment rights. Now, that's one prong. The other prong that the Pennsylvania Supreme Court ruled on, remember that the first trial, Bill Cosby's first trial, was focused on one accuser, and none of the other accusers' stories were admitted into evidence, and that resulted in a hung jury. The second time, the trial judge allowed all of these other accusers who weren't actually charging him with a crime, whose allegations were not actually part of the case against him. All these other people were allowed to come in and say bad things about him, and that's not permissible in a criminal trial. And while the primary prong that the Pennsylvania Supreme Court decided Cosby's case on was this Fifth Amendment issue, they also commented on the impropriety of allowing all of these other people who weren't going to charge Cosby to come in and say bad things about him. We call it other bad acts evidence, 404B evidence. And the Pennsylvania Supreme Court said, that's not permissible. You can't do this. So there were two reasons why this got overturned, and I think what we see from the oral arguments in this case is the Pennsylvania Supreme Court is really fed up with prosecutors and the way that they are trying to engage in character assassinations of people who are accused of sexual assault.
That is a great explanation. And, I mean, I guess at first glance, it looks like a technicality, but I mean, when you explain it that way, so I would assume that you don't agree that this is a mere legal technicality.
Well, I don't, Erica. Your right to remain silent is not a legal technicality. It's a fundamental protection guaranteed by the first 10 amendments, the literal Bill of Rights that our government is based off of. When the government gives you its word and promises to do something, and that promise makes you do something that's against your self-interest, they can't go back on it. We were talking in court about this the other day. It's actually the legal equivalent of the no takesies backsies rule. You can't make that level of promise and then say, oh, I was kidding. There never would have been a civil case against Cosby if the prosecution hadn't induced him to testify. The misconduct in this case, and the trauma that the accusers who testified and have now had that criminal conviction ripped out from under them, has absolutely nothing to do with Bill Cosby. His actions are what they are, but the events of the last 2 days can be directly traced back to the prosecutor who made the decision to grant this immunity and the accuser who chose to pursue money over criminal justice all those years ago. She could have made the decision, I want the criminal prosecution to go forward. She could have said, I am not going to pursue a civil lawsuit. I am not going to depose Bill Cosby. Let's let the statute of limitations continue to run until this prosecutor or some other prosecutor will go after him criminally. And if she had made that decision rather than to go after money, we wouldn't be in this position. Now, maybe we would be in this position because of the 404B evidence, but maybe not. That makes their case all that more persuasive when she's not just going after money. She's actually going after the criminal remedy that's available to her. This is an example, Erica, of the justice system working the way it should. That accuser made a choice to pursue money over conviction over a decade ago. And because that happened, because Bill Cosby gave up his Fifth Amendment rights, the prosecutor cannot now use those statements to attempt to convict him today.
Wow. I mean, that is such an interesting perspective. I'm going after money instead of conviction. I just haven't heard it explained that way. So thank you very much. I'm sure that the listeners are all in awe of how you've explained that. So thank you so much. So what's next for Cosby?
This conviction is vacated. He'll be released from prison. He has been released from prison. He has no conditions. He could explore a civil lawsuit against the state for prosecuting him in violation of their agreement. I think he will have to prepare for other jurisdictions attempting to bring criminal charges against him. There are dozens of other accusers. And depending on the civil statute of limitations in various jurisdictions, he may have to face additional civil lawsuits as well. So Bill Cosby will be continuing to go to court. His freedom may still very well be in jeopardy. But for the time being, he is a free man.
Wow. It's an incredible turn of events.
It is, and it's based on, I believe, an accurate interpretation of the application of our Fifth Amendment rights. But our featured topic this week, Erica, is our Fourth Amendment rights, which is honestly one of my favorite amendments. I think the Fourth Amendment protects us or should be protecting us more than any other uh, aspect of the Bill of Rights, because it protects our right to privacy, which in turn gives us unparalleled freedom in this world. Um, the reason the founding fathers and the authors of the Bill of Rights were so concerned with the privacy rights of citizens is found in the abuses that the king committed against the people living in the colonies in the name of the king's justice. In other words, based on the experience that they had being ruled by King George, that equipping government officers with unfettered discretion to do whatever they want, whenever they want, to search and seize people is the most oppressive tool that a government can use. And we see it even today. We see it in places like Russia, where people just disappear and we never hear from them again. We see it in places like Latin America, where law enforcement, paramilitary groups go into camps and just ransack people's homes. That ability, that lack of Fourth Amendment protection, um, is why I think the Fourth Amendment is the most important aspect of the Bill of Rights.
And that is a great explanation. Can you, I'm sorry, three, two, one. And it is interesting because I know that there have been cases that we've talked about in the news where, hey, he drove onto his property and he got into his garage, but he was given, the walk and turn test right there in his driveway. I mean, it's in some cases people think of their home as like, not it, I'm home. you know um, this is my safe zone. Like running like crazy as if it's the embassy and they're in a foreign country. um, Maybe you can tell us exactly what the Fourth Amendment rights are and how they can protect us.
Well, to really understand what the Fourth Amendment protects us from, we have to go back to the time of the American Revolution. And the British were subjecting colonists to general warrants. What is a general warrant? Well, a general warrant gave any law enforcement officer or military military person license to search whatever they wanted, whenever they wanted, without any reason, with impunity. Time and time again, I have clients who have warrants executed on their home, legitimate, properly issued search warrants. And you should see the mess that police leave in their wake when they come into your home. They take the drawers out of the dresser and they dump it on the floor. They take your countertops and they just throw everything off of the counters. They have absolutely no respect for your things. And this is modern day police. You can imagine how King George's lackeys behaved back in the 17th and 18th century. Now, because the king's ministers could issue general warrants on their own authority, these devices also opened the door to unchecked executive power. So the people that the king put in place to govern the colonies would abuse that privilege to search their business rivals' warehouses, to destroy their goods, to terrorize their family and try to run them out of town. Boston lawyer James Otis, who popularized the slogan, "Taxation without representation is tyranny," everybody's heard that, denounced general warrants in a legendary speech where he said, "The worst instrument of arbitrary power is the general warrant, which places the liberty of every man in the hands of every petty officer." And what he's saying there is that, if we didn't have the Fourth Amendment today, imagine this. Imagine you're driving down the road and you're driving, a politically divisive vehicle. Let's say you're driving a Prius, and the police officer is one of those guys that drives the great big pickup trucks that shoot the black smoke out of the exhaust pipe, and he doesn't like Prius drivers. Well, if we didn't have the Fourth Amendment, the police could just pull you over for driving a Prius and literally dismantle your car on the side of the road in the name of a search for contraband and just leave you there. You know, John Adams later called Otis's speech the first scene of the first act of the arbitrary claims of Britain and its opposition to those claims. Then and there, the child of independence was born. And I couldn't agree with Adams more. When the colonists realized the dangers and the oppression that the general warrant imposed upon them, I think that was the moment where they said, this isn't workable anymore. He can't do this to us. But under the Fourth Amendment, now police have to have legitimate reason to stop you. Police have to have legitimate reason to search you. Police have to have legitimate reason to take you into custody and haul you off to jail. And if they do those things, on the back end, they're going to have to answer to a judge. They're going to have to explain their actions and they're going to have to justify their actions. And the Fourth Amendment gives us all of those protections. That's what the Fourth Amendment protects us from.
Wow, that's really interesting. Can you imagine living back in that time? I mean, I know that we have a lot of crazy stuff that happens now with our rights, but I mean, no one's just walking in your home. Well, I mean, it does happen. And that's why we have this show, but it's not happening every single day to every single person. So we have to keep getting it to where, we're down to zero tolerance on that sort of thing. And I know
Well,
that that's what we're working at.
Erica, that's what really is one of the variety of things that really offend me about police officers is when you become a police officer, just like when I became a lawyer, you swore an oath. I swore an oath and police officers swear an oath to uphold and defend the United States Constitution. And their disdain for that document, and in particular the Fourth, Fifth, and Sixth Amendments of that document, their disregard for it disgusts me. It's a violation of their oath. They're a bunch of oath breakers. Those that don't respect the Fourth, Fifth, and Sixth Amendment are oath breakers, and that they're liars. You can't trust a liar.
I agree with you. So can you tell us, like, what are the exceptions to the Fourth Amendment?
So there are exceptions because in practicality, the protections given to the public from the lawless actions of the police is an important policy, but it has to give way to social stability at times. The Fourth Amendment doesn't prohibit any search and seizure. It prohibits warrantless and unreasonable searches and seizures. And the exceptions to the warrant requirement, as in times when a warrantless search is lawful or a warrantless arrest is acceptable, fall into essentially three broad categories: consent, search incident to arrest. So if somebody's arrested, they can be searched at that time, and then probable cause combined with exigent circumstances. What is exigent circumstances? Exigent circumstances is an emergency, a really important reason why this search has to happen right now. And we're going to continue talking about these exceptions in the coming weeks. But some of the examples are people who are in imminent danger. If there is a danger to the public, we can toss out the Fourth Amendment and say, this moment is too important. We're not going to go get a warrant. When evidence faces imminent destruction or a suspect is about to escape, imminent escape. And notice we keep saying imminent, 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 because that time frame is critical to establishing the exceptions to the warrant requirement. And I don't want to go too far down that rabbit hole because there's going to be some future episodes.
And I can't wait to hear them, because I mean, these are all, really interesting points that you're bringing up. And I know that we really dive deep in some of these episodes. So tell us, just how can we see the Fourth Amendment in our daily lives now?
Well, the Fourth Amendment protects our privacy in places where we have the reasonable expectation of that privacy. So when we're out in the public, on the road, in parks, in government buildings, We can lawfully be watched by police. We can be stopped briefly and questioned by police. But when we cross into our private realm, the more private the space, the more protections we get. So, walking down the street, police can watch you. In your car, police maybe can't search the interior of that car without a little bit more reason. In your home, they better have a warrant. Um, you know, to and then even further in there, in your home in a locked safe, now they've got to get another warrant. So the more privacy that you assert, the more Fourth Amendment protections you have, which is why it's critical to always assert your rights, right, Erica? You've got to say, no, you can't search me. No, you can't come in my house. No, 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 no. Go talk to a neutral and detached magistrate. Go get me proof that this is a legitimate government action, and then I'll let you do it. Every time we're asked to voluntarily submit to a search without a warrant, the answer should be no. And every time a person gives away that right, all of us, as freedom loving Americans, lose a little bit more of our protections from government overreach.
Well, I couldn't agree with you more. And it's about setting those boundaries and being able to have those boundaries. I mean, it's huge.
Absolutely, Erica. We are living in the age of consent, where consent is so important in so many areas. And just like you shouldn't give away that consent easily in the bedroom, you shouldn't give away that consent easily in public either. I want to thank you, Erica, for speaking with me today and diving into these difficult topics, but critically important topics. And everybody who joined us and hears this show, thank you to you as well. To become informed about the latest news with the latest police involved shooting, government and police accountability, warrant requirements of the United States Constitution, and all of your constitutional and civil rights. Check out the law office of brianjones.com, facebook.com/Central Ohio Criminal Defense, and on TikTok, Instagram, and Twitter at TLOBJ. We'll be back next week with a sui generis perspective on the hot topics in civil rights and the criminal injustice system, as well as a deep dive into the automobile exception to the Fourth Amendment's warrant requirement. Now, Erica, my grandfather always told me when we parted ways, hey, kid, don't do anything I wouldn't do. And to that, today, I add, if you do and you get caught, call me. I'll defend your rights as I'd want mine defended.